Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
So imagine you're just opening your mail today, right? And you find this massive, multi-million-dollar lawsuit just waiting for you.
Oh, that sounds like a nightmare.
Right. And your crime. You sent a text message to a friend, and that text message happened to contain the letter E.
Just the letter E.
Just the letter E.
Mm-hmm.
Because this lawsuit is claiming that some massive tech corporation recently secured, the exclusive patent and copyright for the letter E. And now you owe them a licensing fee for every single time you tap it on your keyboard.
Which is, completely unhinged.
It sounds like a dystopian joke.
Yeah.
But today, we are jumping into a deep dive that uses that exact kind of absurdity to explain the invisible rules governing basically every single idea in your head.
Yeah, because it really is the ultimate boundary line of our modern world. We are looking at where the raw, unownable materials of the universe end and where legally protected human ingenuity actually begins.
Yeah, exactly. And the lens we are using to examine this boundary today is something you probably haven't thought deeply about since, like high school geometry.
Oh, definitely not.
We're talking about the number pi, 3.14. We've got a really fascinating set of sources today that link Pi Day to the incredibly complex and, frankly, often messy world of intellectual property or IP law.
It is super messy.
Right. So the mission for our deep dive today is to explore how this one mathematical constant perfectly illustrates the delicate balance between the shared human commons, the stuff that belongs to all of us, and the things that a single person or a company can actually legally own.
Because if you don't understand that balance, you really cannot understand how the modern world functions. This isn't just about abstract math.
No, not at all.
This is the legal machinery dictating how you stream music, why your life-saving medications cost what they do, and, like we'll get into later, how society is currently just panicking over artificial intelligence.
Okay, let's unpack this. Because before we can figure out how the law builds a fence around an invention, we have to establish what is absolutely fundamentally unfensible.
The bedrock.
Yes, the bedrock. And that is exactly where pi comes in. Pi is a mathematical constant. If you draw a perfect circle, the ratio of its circumference to its diameter is pi. No one sat in a laboratory and invented that ratio.
Right. It was discovered.
It was discovered.
Yeah.
And that distinction between discovered and invented, that's kind of everything, isn't it?
It is the entire ball game in intellectual property law. Because pi is a fundamental truth of reality. It sits in the exact same legal category as, the theory of relativity or the concept of gravity or just the fact that water freezes at 32 degrees Fahrenheit.
Right.
You fundamentally cannot claim ownership over the laws of physics or basic facts of the natural world.
Which brings us back to that ridiculous lawsuit over the letter E.
Exactly. The alphabet, basic numbers, biological facts, these are the essential building blocks of human communication and progress.
The raw materials.
Yeah, the raw clay. In legal terms, we call this the public domain or the commons. The bedrock principle of IP law is that foundational knowledge just has to remain completely free and accessible to everyone.
Because if it isn't, the system just cannibalizes itself, right?
Yeah.
Imagine if Sir Isaac Newton had been able to patent the concept of gravity.
We'd be in trouble.
We wouldn't be able to build a bridge or, drop an apple or design an airplane without paying his estate a royalty fee.
It would be a complete stranglehold on human development. The law recognizes that we all need access to that same raw clay to build our society. Fencing off the clay is strictly prohibited.
So the math is free. The facts are free.
Yeah.
But I'm looking around my desk right now, and basically almost everything I see is patented, trademarked, or copyrighted.
Pretty much, yeah.
So if the foundation is completely free, where exactly does the legal fence get built? How do we actually separate the free clay from the owned object?
So the law relies on a mechanism known as the idea-expression dichotomy, alongside some very, very strict criteria for patents.
Okay.
To put it simply, you can never own the raw idea or the foundational fact, but you absolutely can own the highly specific, novel way you express or utilize that fact.
Let's break that down, because I think people tend to just lump all intellectual property together into one big bucket.
Yeah.
But copyright, trademark, and patent, Those are completely different tools, right?
And completely different. And let's use pi to separate them, starting with copyright. So copyright protects the expression of an idea.
The expression.
Right. You cannot copyright the number pi. But if you spend a year writing this wildly entertaining 300-page textbook explaining the history of pi, complete with, your own personal anecdotes and hand-drawn illustrations.
Then I own that.
Yes, you absolutely own the copyright to that specific book.
Because the book is the human expression. Like, I can't steal your chapters, but I am still perfectly free to go write my own entirely different book about pi.
Precisely. Now let's look at trademark. Trademark is entirely about commercial reputation and consumer protection. It protects brands.
Okay, so how does that work with pi?
Well, you can't own pi, obviously. But if you start a math tutoring franchise and you call it Perfect Pi Tutoring, you can trademark that name and your specific logo.
But I'm not owning the math. I'm just preventing, like, a rival tutoring company across the street from calling themselves Perfect Pi and tricking my customers into walking through their doors instead.
Exactly. You own the commercial identifier, not the underlying concept.
Got it.
But then we get to patents. And this is where the line gets incredibly sharp. Patents protect utility and invention. We're talking new processes, machines, or chemical compositions. To get a patent, your invention has to be novel, useful, and non-obvious.
Wait a minute. If an engineering process or a software algorithm relies completely on pi to function, aren't they basically just sneaking in a patent on the math itself?
Well,
Because I'm thinking, like, self-driving cars. If I write a highly complex software algorithm for a self-driving car, the entire code is essentially just advanced calculus and geometry, heavily relying on pi to calculate turning radiuses.
sure.
Software is literally just math compiled into logic gates. So if I patent that software, how is that not a contradiction of the public commons?
What's fascinating here is how a patent examiner actually resolves that exact contradiction. You are hitting on one of the most heavily litigated areas of modern law right now.
Really?
Oh, yeah. The short answer is you cannot patent an algorithm if it is just a mathematical formula sitting on a piece of paper or, living abstractly in a computer's memory. The law requires a physical, real-world transformation.
A physical transformation. What do you mean by that?
Think about the anti-lock braking system in your car. That system uses the formula for the circumference of a circle, which obviously requires pi, to calculate exactly how fast your wheel is spinning in milliseconds.
Right, okay.
You cannot patent the formula A equals pi r squared. But if you design a physical sensor that uses that mathematical calculation to physically trigger a hydraulic valve that pumps the brakes and stops a car from skidding on black ice, that is patentable.
Ah, I see. So the scalpel the law uses is the physical application.
Exactly.
The math is just the tool, but the invention is the specific arrangement of sensors and valves solving a literal real-world problem.
Yes. You aren't claiming ownership of pi. You are claiming ownership of a highly specific, novel physical process that happens to use pi to save a human life. The underlying math remains totally free for anyone else to use to build, a completely different kind of brake system.
Here's where it gets really interesting, though. We have this massive, complex legal apparatus, patent examiners, copyright offices, international courts, constantly trying to separate the universal truth from the human invention.
It's a massive industry.
Why do we even bother? Like, why is the law designed as this constant tightrope walk?
If we connect this to the bigger picture, it is all about manipulating human behavior and economics. Intellectual property law is essentially a massive societal lever used to drive innovation.
Yeah.
And it works by balancing two fiercely opposing forces.
Right, the open commons versus the private fence.
Exactly. We already discussed the dark age that would happen if we fenced off the commons. If you let people own gravity or the alphabet, innovation just grinds to a halt.
Small inventors are totally priced out.
And science basically becomes a toll road. But what happens if we slip off the tightrope in the other direction? What if we abolish IP entirely?
Just zero patents, zero copyrights.
Right. Everything is perfectly free and open to everyone the literal second it is created.
I mean, in a utopian sense, that sounds kind of great.
Yeah.
Like all human knowledge is instantly shared.
It sounds totally utopian right up until you introduce the reality of financial risk.
Ah.
Let's look at the pharmaceutical industry. It can take $1 billion and a decade of clinical trials to discover a novel chemical compound that cures a specific type of cancer.
Right, and most of those trials completely fail, so the financial risk is just astronomical.
It's massive. Now, imagine a world with no patents. That company spends $1 billion, they finally create the pill, and they bring it to market.
Okay.
The very next day, A rival company buys one single pill, reverse engineers the chemical formula, which takes maybe a week and costs almost nothing, and they start mass producing it.
Oh, wow. So the rival company can sell it for a fraction of the price because they didn't have to spend $1 billion on research and development.
Which means the original company instantly goes bankrupt. So knowing that will happen, what does the original company do?
They never bother trying to cure the cancer in the first place.
Exactly.
The financial incentive is completely vaporized.
Without the temporary monopoly of a patent to recoup their investment, the cure is never invented. And the same applies to software engineering and even art.
Right. Like, why spend 2 years writing a novel if anyone can instantly print and sell copies of it without paying you?
Intellectual property law exists because the investment of human capital requires the security of temporary ownership. We need knowledge to be free, so we have the tools to invent, but we need inventions to be owned, so people will actually bother inventing them.
So what does this all mean for you, the listener? Because we've talked a lot about, anti-lock brakes and billion-dollar pharma companies. Let's bring this tension down into your kitchen and your living room.
It's everywhere.
It is. The sources we're analyzing explicitly move this IP balancing act into everyday media.
Yeah, the rules don't change just because the stakes are smaller. That idea-expression dichotomy we talked about is everywhere.
Let's take a cookbook. A single standard recipe is generally not protected by copyright. Like if I write down, combine 2 cups of flour with a teaspoon of baking soda and bake at 350 degrees, I cannot own that.
Because a recipe, at its very core, is just a list of factual instructions. It's a standard procedure.
It's basically chemistry.
It is the chemical equation for baking bread. You cannot copyright a fact. That is the pie. That is the public commons.
But if a chef spends 3 years testing variations, curates a highly specific collection of 100 recipes, weaves in deeply personal essays about their culinary journey, and shoots gorgeous photography for every single page,
then that entire cookbook is heavily protected by copyright.
because they've transformed a list of unownable facts into original human expression.
Exactly. The curation, the narrative, the visual aesthetic, that is the uniquely human structure built on top of those free bricks.
Okay, what about streaming music?
Yeah.
Because you can't own the broad concept of streaming digital audio. That's just moving data from point A to point B over the internet.
Right.
I've tried to visualize the legal boundary here, and it basically feels like the difference between water and plumbing.
Oh, I like that. Go on.
Well, the fundamental idea of streaming data is just water flowing downhill. It's an elemental functional concept. You can't patent gravity moving water.
Right.
But a platform like Spotify or Apple Music, they aren't claiming they invented water. They are claiming they built a highly specific proprietary plumbing system.
Yeah, the pipes.
The algorithm that analyzes my listening habits, the specific user interface, the server architecture that ensures the song doesn't buffer. That is their patented and copyrighted plumbing.
That is exactly how the law views it. They own the specific execution of the delivery system, not the concept of delivery itself. And anyone else is legally permitted to build their own completely different set of pipes to move the same water.
Which makes perfect sense.
And honestly, that is a perfect segue into the most complex and urgent topic our sources tackle today.
Yes, artificial intelligence.
This raises an important question, and frankly, it is the defining legal crisis of our generation right now.
It really is everywhere.
We have spent this entire deep dive establishing that facts, math, and data are free public commons. And we've established that IP law is designed to protect original human expression.
Right. Humans get the copyright, the math doesn't.
But what happens when a machine uses the math to simulate the human?
Oh, man.
Think about how a large language model actually works. It does not have a brain. It does not have feelings or, ideas. It is an unimaginably massive statistical probability engine.
Right.
It scrapes millions of unownable facts, words, and images from the internet, and it uses complex mathematics, literally the ultimate form of pi, to predict which word should logically come next in a sentence.
So to use our metaphor from earlier, an AI is basically a chef that has statistically analyzed 10 million recipes, but it possesses absolutely no taste buds.
Yes, it is pure computation. It is ingesting the public commons. But here is the crisis. When the AI outputs a new poem, a piece of code, or a beautiful digital painting, it looks exactly like original human expression.
It really does. But legally, is it? Like if I sit at my computer and type a prompt that says, write a 500-word essay about intellectual property in the style of Shakespeare, and the machine spits it out in 3 seconds, Who actually owns that essay?
That's the million-dollar question.
Do I own it because I wrote the prompt? Does the AI company own it? Or does nobody own it?
Well, as of right now, the U.S. Copyright Office has drawn a hard line in the sand.
Okay.
Nobody owns it.
Wow, really?
Yeah. They have ruled that AI-generated works lack the required human authorship. The machine's output is considered a mechanical generation, basically akin to a calculation.
It's just math.
It is math. And as we have established, you cannot copyright math. If an AI generates a completely novel image, that image immediately falls into the public domain. It is free clay.
Wow. So I can't write a prompt, generate an entire novel using an AI, and then claim copyright over that text to stop someone else from selling it.
Not if the AI wrote the text. Now, if you take that AI-generated text and you spend months heavily editing it, rewriting chapters, and infusing it with your own unmistakable human creativity,
Then what?
then you might be able to copyright your specific edits. But the raw AI output is fundamentally unownable. The law is currently treating the AI as an incredibly advanced tool, kind of like a camera.
Okay.
You don't own the landscape the camera captures. You own your specific framing and lighting of the photograph.
But that boundary is getting blurrier by the minute, isn't it? I mean, writing a highly complex prompt to an AI engineering the exact parameters, the tone, the context, doesn't that require a form of human ingenuity?
And that is exactly what lawyers are fiercely debating right now in federal courts.
I bet.
Is prompt engineering a form of human expression worthy of copyright, or is it just pressing a button on a very fancy slot machine?
It totally reframes how you look at the technology we rely on every single day. We are interacting with these mind-boggling complex systems, but underneath the algorithms, the branding, and the patents, there is this foundational bedrock of shared free knowledge just holding the entire structure up.
The ultimate takeaway from our depth dive today is that intellectual property law is not just a bunch of corporate lawyers trying to put padlocks on ideas.
Right.
It is actually a surprisingly elegant, if highly imperfect, system. It is designed to ensure that the public commons remains fertile while still giving you the financial and legal cover to plant a seed and watch it grow.
So the next time Pi Day rolls around, whether you are trying to calculate the circumference of a circle or just grabbing a slice of cherry pie, think about that number as a reminder.
Absolutely.
It is the raw material of the universe. It belongs to all of us. But what you decide to build with it, that is entirely up to you.
But I do want to leave you with one final, slightly unnerving thought as you consider the future of that public commons.
Uh-oh. Lay it on us.
We just established that AI outputs are currently considered unownable math. But as these models become exponentially more sophisticated, as they become capable of generating entire video games, designing viable architectural blueprints, or, composing symphonies that move us to tears, will the legal definition of human expression have to fundamentally break? If a machine's mathematical calculation becomes entirely indistinguishable from the human soul, will we eventually allow algorithms to start putting fences around the very commons they were built on?
That is a massive question to chew on. From the universal truth of a high school math equation straight into the murky, uncharted waters of our digital future. Keep an eye on where those legal fences are being built. Keep questioning the structures around you. And as always, keep diving deep.